All right, why don't we get started? I'm John Haigh. I'm the co-director of the Moshe Rahmani Center for Business and Government. Usually I sit over there and kind of introduce these things. Today, I'm actually partially participating in this panel. The topic today is one that we all seem to have a lot of interest in. In particular, all of us on the panel and people can talk about their own experience in one form or another have addressed questions of antitrust, questions of competition policy. My background is a little unusual for the Kennedy School in the sense that I was in the private sector for 20 some years. I ran AT&T's international operations. I ran new services for AT&T Wireless. So I engaged primarily from the business side or a firm perspective. As opposed to a pure regulatory perspective. But we have an incredible group of people here. Gene Kimmelman is going to moderate, and I will leave it to Gene to kind of introduce himself and let him lead the show.
Okay. Thank you, John, and thank everybody for being here. You've got veterans of government, great academics, people from the business sector in a previous life. And we wanted to frame up a little bit what's been going on with the big tech antitrust cases, and particularly focus on the results that have come in so far. But to start, I want to step back a second and say, when I came into the work in the Justice Department in the beginning of the Biden administration, there was tremendous expectation that the administration was about to launch a much more aggressive approach to antitrust enforcement than in the past. And it came at a time when the Trump 1 administration had actually already filed a monopolization case to challenge Facebook's purchase of Instagram and WhatsApp as being an effort to take out potential competitors and monopolize the social personal networking market. And they filed a case against Google for monopolizing the search market. Subsequently, what we've seen is a second case against Google for monopolizing the display advertising market. Which the DOJ won the case. We're awaiting a remedy decision. And there are pending cases against Apple for monopolization and Amazon for monopolization, all which emanated from the Biden administration's continuation of what it started in the first Trump administration and then expansion of it. And we're starting to see results, but I wanted to use as a way of teeing off the conversation here. The Financial Times on the 4th of January ran a major piece titled "The U.S. is Losing Its Battle to Break Up Big Tech." And in that article, for the cases we're about to describe a little bit more in detail, the former head of the Antitrust Division, Jonathan Kanter, is quoted a number of times, and he basically says some pretty interesting things, I think. He says, "We were reviving the law from the dead. We're reviving the antitrust law from the dead, and that takes time." And then he goes on to say that we were too slow to react in real time to anti-competitive practices in the marketplace. And the lesson he takes from that is that we should not let monopolies form or maintain themselves illegally in the first place. He goes on to say that we just need to keep bringing more of these cases, and that he sees a silver lining in the results, even where there are losses or remedies that are weak, because he says, if you find liability, the remedies will come. So that's the framing from the former head of the Antitrust Division. So I want to start with the Google search case, which had a finding of liability of Google for monopolizing the search market, text advertising market, with some pretty strong language from District Court Judge Mehta in DC, finding that the contractual relationships with the manufacturers of Android devices involved payments and involved contractual limitations that favored Google. Similarly, enormous payments to Apple for a default positioning as the search engine on the iPhone, upwards of $20 billion a year. The judge found these practices to be monopolistic and giving Google an insurmountable advantage of control of data, personal data, critical to the search process, thwarting any growth of potential competitors, existing competitors in the market, to be able to challenge them. And then he comes out with a remedy which requires very little of Google, most people think, but we can discuss this a little bit more. Some sharing of data with actual and likely competitors who are in the adjacent AI, generative AI market. Some syndication requirements that reflect what Google was already doing as a business practice. It's maybe slightly expanding it. Rejecting the government's demand that Google be required to divest Chrome, the Chrome browser, major tool through which a lot of search traffic was traveling, and favoring Google. No consideration of a divestiture of Android operating system, which was a backup from the government, and effectively no limitation of payments to the Android device manufacturers or to Apple, other than in the form of saying there can be no exclusive arrangement that goes beyond 1 year for default placement of Google search, and no tying of its other services to that. So very disappointing to many of us who had come in seeking to really push the envelope in antitrust enforcement, and raises this question: does the FT have it right that it's a lost battle here to break up big tech? So with that, I want to turn to Jason, just tee it up here, and thoughts about first the antitrust piece, but I do want to get to the other work you did for the report that was done for the UK and on beyond that. But let's just talk about the case a little bit.
Yeah. So first of all, it's great to be with all these people who all know more than me. So I'll say something and then hopefully listen to them for the rest of the time. Also want to contextualize this conversation. There's just enormous amounts of discontent with big tech, with wealth inequality, with political power. Some people don't like the current administration. Some people don't like AI slop, et cetera, et cetera. I don't think anyone on this panel, though somebody should speak up if they feel differently, thinks that you can really in any material way solve any of those problems with antitrust. With antitrust, what you can do is do a better job for innovation, varieties of products, cheaper products, better products, and ultimately a better job for consumers. So I think in some ways there's a technocratic conversation, which is largely the one or entirely the one that was happening in the courtroom, which is a really, really important one about can you make the world somewhat better, or are you going to mess up and make the world somewhat worse? And then there's this bigger conversation, and they're often very disconnected. When it comes to the Google case in particular, I thought Judge Mehta's liability ruling, I read it from beginning to end, and I thought it was just terrifically reasoned and argued and written from beginning to end. It's a great economics lesson, a great technology lesson. And, on days when I worry about economists being in decline because I look at commentary about antitrust on social media, if you read that decision, it wasn't antitrust on social media they were citing, it was economists. And the judge, I think, did a good job of sorting out good from bad ones. And to steal a point that Nancy's emphasized before, it includes behavioral economics and some cutting edge economics. Then the remedy came along that also makes for riveting reading. It's a little bit shorter than the liability ruling. And I think three things were going on there, some of which I'm somewhat sympathetic to. One, a sense that the world had changed. The case was initiated in 2020. The liability ruling was in 2024, which is sort of fast by antitrust standards. I'm sorry, and then the remedy was a year after that. That's sort of fast by antitrust standards, but a lot changed in that time. Google's search share of ad revenue fell below 50% over that period of time. TikTok rose to enormous extents. more people started effectively searching through things like Amazon and TikTok. And then, of course, AI came. And to some degree, that surprised me. I thought AI was only going to emerge from the existing big tech companies because they're the ones that had the data, they're the ones that had the scale to get the capital. But you get OpenAI and Anthropic. Now, important funding from places like Amazon and Microsoft, but it's hard to say that they're closely tied or entrenched to them. So, the first thing is the world changed. The second is that the judge was very small c conservative and very worried that tweaking, so I have sympathy with that. The second, very worried about tweaking stuff that might break things. So if you read even the original liability finding, it basically grants that Bing is not necessarily as good a search engine as Google, but argues that if more people used it, it would get better and then they'd like it more. So in some sense, when I was reading that, I actually was nervous that we'd be in a world where you force everyone to use a product, not force them, but sort of push, nudge, whatever, them to use a product that's actually maybe worse on some speculative theory that it will lead to competition that somehow improves that product in the future. That involved, to me, sort of a lot of leaps, and maybe that was what was going through the judge's head when he rejected some of the structural remedies vis-a-vis Chrome, which is the main way in which you would have had a breakup coming out of this. The place where I have, the third thing though, the place where I have much, much less conviction is it's hard for me to see the very large benefits of the scale of the payments that Google makes. It's hard for me to see what the sort of downside harm if you make a mistake and limit and rule and ruin those. If there really is a big difference between these products, consumers can change. If there's not a big difference between these products, then who cares? So to me, that's the place where you could most easily persuade me that the judge had erred. And then the last thing I'll say is, we've seen other cases too. And I think the Meta case was another one where, to some degree, some of the non-economic arguments almost cut against that case. And the judge seemed almost angry about some of what he saw as economic illogic of them. And so ultimately, better grounded economic things. I don't think it gives you a definitive answer in any of this, but it probably narrows the space and focuses the discussion a little bit more. And more of that going forward is probably a good thing.
So let's come back to the Meta case in a little bit, but Nancy, your reactions to this. Agree, strong, well-reasoned liability decision, and then what about the remedy?
Major disappointment. So I would not dispute Jason's, actually all three of Jason's points. The world has changed. I think that is part of what the judge was hoping would rescue his non-remedy. The judge is, I think, definitely the remedy opinion speaks like someone who is a very, a small c conservative. I don't want to risk harm, so I'm just going to do nothing and hope that that is okay. And I completely agree with I don't see the problems that he was worried about as being enormous problems. Apple's a big company. If it loses $20 billion of monopoly payment that it was bribed with to stay out of the search market, which is my view, not in the case, not argued by the plaintiffs, but as an economist, when I read the initial complaint, I found it impossible to understand why Google would have to pay Apple $20 billion to be the default on the Apple iPhone. If Google was what everybody wanted, Google could just say to Apple, well, if you put Bing on, your customers are all going to be unhappy. So, up to you. But, if you don't make us the default, your customers are going to scream. If Google's really that much better, they don't have to pay Apple to get that. If they're not any better, then there's a problem with that deal. And I honestly thought at the time the way to understand it was a way of making sure Apple found it so unattractive to think about entering that in competition with Google, that it would just leave the field to Google. And so the judge's concern about, gee, what would happen to Apple or to Samsung and other device manufacturers if Google wasn't paying them money for this, just didn't resonate with me as an argument against saying to a firm that has been found guilty of monopolizing a market, there are consequences to that, and they're significant. And one of them is that you can't share your monopoly rents to try and make sure that you maintain your monopoly position. So I found that just extraordinarily puzzling, that the judge would come out that way. At the same moment, you could say, all right, you know, search is Google search is something that many consumers think have made their lives a lot better. I don't want to screw it up. I think there were a number of elements of the plaintiff's suggested remedies, and some that they didn't think of, but you could have put together with, or they didn't request, that you could have put together as a judge with what you decided to do if you weren't going to take some of their more assertive ones, that could have made some difference. And, you know, I want to pick up on the behavioral economics point that Jason made. The judge did embrace the evidence at trial and liability on the role of consumer decision-making and how important that was to understand the influence of these exclusive default contracts that Google signed. There's a group of 5 economists, one of whom is my colleague at MIT, that did an experiment, real-time experiment, that is, I think, was cited by, I think, both parties and the judge. So everybody found something to like in this during the remedies hearing. And they ran a series of experiments that involved asking consumers to first maybe be exposed to a choice screen and see whether that changes your default of search engine. To forcibly move you, so to Jason's point, where we're going to force people off of the search engine they love to one that they don't. But so, you know, they experimented with that. What happened if you forcibly moved people from Google to Bing? You know, how quickly did they come back to Google? What were the implied kind of frictions that prevented that? What I found most interesting in their series of, I think they had about a half a dozen different types of treatments, was they had one treatment arm that involved paying consumers 10, 15, 25, I think were the dollar amounts, to switch from Google to Bing for 2 weeks. Lots of consumers took them up on that, and many of those consumers stayed with Bing after the 2 weeks were up. And when they furthermore tried to investigate what the effect, you know, why did people do that? Was it just that it was, you know, such a pain to switch back? What they discovered is that many people had positively updated on their evaluation of Bing's quality. So part of what this series of experiments revealed is that people just didn't know very much about Bing. And if you used Bing, you realized, you know, it's not as different than Google. In fact, maybe there are aspects of it that I prefer. And I was disappointed. You know, the states, for instance, I think asked for an education campaign to be funded by Google. I'm not sure that would have had a lot of effect, but I think that combined with Google funding consumers trying Bing for 2 weeks could have been a very powerful way to try and open up the market. And I just feel as though on, you know, point by point by point of the suggested remedies, the judge was extraordinarily disappointing. So, you know, you can't sign exclusive default contracts that last longer than a year. And it has to be possible for Apple to say, well, we want to exempt Nancy's iPhone from the default contract, so it's not really exclusive because she's not defaulted to Google. I mean, this is ridiculous, right? You've got a firm that has made billions and billions and billions of dollars by keeping everybody else out, by disadvantaging their rivals, and you say to them, we'll make your contracts a year and you're fine. Or you tell them, you know, you have to syndicate some of your data that syndicate some of your results that you're already syndicating, but we're going to make you do more of that. I felt as though what we signaled was, if you're big, monopolize the heck out of your market. And if and when finally antitrust comes to reckon with you, just pay your lawyers a lot, see it through to the end. And in the end, we'll slap you on the wrist and you can go on your merry way. And I think that's really bad because antitrust is fundamentally a deterrence-based system. And if the consequence of violating the law is go on your way, I kind of think we don't have an antitrust system.
So you think that the weakness from your perspective of the remedy actually undermines the fact that there was a liability finding, in essence, that this is all antitrust will do in this type of a circumstance, which is almost a
Worse
cost of doing business for a large firm like this.
I would say, prior to the US engaging, Europe did much more assertive antitrust enforcement against the tech companies. And they just looked for fines. That was sort of their potential remedy. So they fined these companies, sometimes, $10 billion. And the companies viewed that as a cost of doing business. We've now, with better tools in principle available, gone through this route. And I think, in fact, from an antitrust perspective, it probably would have been better to not bring the suit at all than to bring one with an ineffective remedy. Maybe not. It did take up some Google exec time, and they didn't especially like that. But, in the end.
So without diving into the Microsoft case, there was always a big debate about, was the Microsoft case successful or not? How much did it really influence a change in the market? What we know is there was a substantial change in behavior of the company itself as the Googles and the Facebooks grew. That there was at least some kind of a cloud over Microsoft's head, I'll just say. I think that's at least a baseline consensus of observers. It sounds like you're suggesting here that there's not even that.
I mean, I don't want to get into a lot of other cases, but Google execs blatantly disregarded document retention orders to purge chats in which they discussed potentially anti-competitive actions, like post the filing of the cases. So I'm not sure I see a particular change in their approach.
So
I'm being a little more assertive than I would usually be on this. I like to respond to Jason and see if I can nudge him.
I trigger Nancy.
Yeah.
It's a problem.
But I will just say I was so disappointed by this, and I was very disturbed by the judge in the ad tech remedy during the hearing on that, seeming to suggest that, oh my gosh, it might just be too complicated to think about a structural divestiture when Google assembled its market power in the ad stack by buying other companies. And usually we think if like a merger contributed to monopolizing behavior, you could at least require divestiture of your merger. Although you'll get to the Meta case, so maybe we don't think that.
But I want to draw in Mike Walker. We're fortunate enough to have Mike here, who ran the economics for the Competition Market Authority in the UK until very recently. And we're probably involved in looking at Google at various points of time in the CMA, and looking at it both from the view of the new law that was ultimately passed, but also from the antitrust enforcement angle. Your observation on Judge Mehta's decision?
Okay, so I think my observations are going to be more about the relationship between antitrust and what the alternatives are, given I think there's reasonable agreement that the Judge Mehta decision is not going to change the world in any substantive way. And in Europe, we've taken a rather different approach to think about these issues. And I testified in front of the Senate Subcommittee on Antitrust, I think in March 21, and about digital regulation. And I said then that we're entering a really interesting area of a natural experiment. We've got the US going with antitrust, just started the Google and Meta cases. We've got the EU at that point just going with its Digital Markets Act, and the UK going with its Digital Markets Unit. All quite different ways of looking at these things. So just, very briefly what we did in Europe, and then talk about how this has or hasn't worked. So in Europe, the European Commission has the Digital Markets Act, which is regulation of big tech, and it's very prescriptive. So it basically says, there's a bunch of core platform services, which are defined. So search, browsers, mobile operating systems, etc. I think there's 7 of them. And then if you are a gatekeeper in one of those, then you have some obligations. And gatekeeper is also defined. Do you have more than 45 million active users or more than 10,000 active business users? Do you have revenues over 75 or 7.5 billion euros or market cap more than 75 billion? All very prescriptive. If you do, then you have a bunch of obligations imposed on you. Things like, you must interoperate. You must allow businesses to contract with consumers that they've been contracted with on your platform, also outside of your platform. You must not self-preference. You must not have anti-stealing provisions. All very, very sort of mandated, not a lot of argument about them. Okay, what do we do in the UK? In the UK, we're a different system. We had this argument, which I think is intellectually the correct one. I'm not sure.
I agree.
So we had a report back in 2019 produced by a guy called Jason Furman, and I think he had some help, which talked about how we might regulate digital markets. And in the UK, we went with that, and we went with a bespoke approach. So the starting point is the firms have different business models. So Google and Meta, they're basically advertising companies. Apple is a device company and a mobile operating system company. Amazon, it's a retailer, ignore the cloud stuff for now. So we're going to have bespoke regulation. So what we do is the regulation came into force early last year, 6 years after Jason's report, so it wasn't a quick process, you look at the firms, you decide if they have strategic market significance, meaning basically, do they have a lot of market power? If they do, CMA can then impose conduct requirements on them, bespoke for that particular market, or very competitive interventions to try and open up the market. Okay, so very bespoke. Okay, so it came into force early 2025. After 9 months, the CMA, of which I was then part, decided, we're looking at Google search, decided Google has significant market power in search. There's a surprise. And that Google and Apple had significant market power in mobile ecosystem. So 9 months to do something that, I think my dog could do in 2 minutes. But that's a process. And that's not a criticism of the CMA. It's a process. Now have 9 months to have a discussion about remedies. And actually last week, CMA published some proposed remedies on the Google search aspect, all sort of quite sensible, some stuff about AI overviews and giving publishers more control and stuff on transparency, all perfectly sensible, not going to change the world. And this is 2026, 7 years after Jason's report, 6 years after we produced a report on digital advertising, where, I must stop saying we, the CMA produced a report on digital advertising saying, actually, ad tech stack, you need to structurally separate it. Double-click merger, shockingly bad merger. Definitely one of the top 3 bad mergers I've seen passed in my career. 5 years after we'd done stuff on mobile ecosystems. So, go back to that, I'll just finish now. Go back to that natural experiment. So, antitrust. Well, that doesn't seem to be working great. As Nancy said, we were very aggressive in antitrust in Europe. We fined Google a lot of money, shrugged its shoulders, took it off the mantelpiece and moved on. We tried to get stuff against Apple on Spotify. That ended up having to wait for DMA and Amazon and so on. Got nowhere. In the UK, we had some antitrust cases. We folded them into DMU because they were going nowhere. We just see what's happened in the US. So antitrust is not now in the race, I don't think. The regulatory approaches are really difficult though, and if I had to decide which is going better, I would say the Europeans, they're at least doing stuff. Apple has to allow alternative app stores in Europe on it. It cannot get. It has to get. It has had to get rid of its anti-steering provisions. It has to allow sideloading. There are changes happening, but they're a bit marginal, you know. And so I'm a bit conflicted because I still think we need some serious structural remedies, and I'm not sure that the regulation is getting there. I think it needs antitrust. But every antitrust attempt I've seen in the UK, in Europe, and the US has got nowhere near there. It's tricky.
Yeah, so let's finish out the cases we have here that have maybe gone nowhere. The Meta case. So this was, I want to get John Salad into this. This was Facebook's purchase of WhatsApp and Instagram around 2010. Very, very small companies as Facebook was exploding, but they were also growing from being very small companies, growing very aggressively in the social networking space. Part of a whole series of purchases by Facebook. They were cleared by the Federal Trade Commission originally. But then again, late in the Trump 1 administration, they sued, claiming that there was a monopolization attempt by Facebook actually in swallowing up these companies to prevent them from competing. So this takes even a little bit longer. Judge Boasberg, I think it took up to 5 years, first dismissed the complaint, that it wasn't specific enough. A lot of signals that this was not a case he was super excited about. But John, it was fundamentally a strong Section 2 case that, with a lot of evidence from early on, with a lot of Mark Zuckerberg testimony of him being scared to death of these companies as potential competitors. But the judge finds that this market, this personal social networking market, may have existed before, may have existed even when the case was filed, but no longer exists, and focuses on the explosion of YouTube and TikTok, and focuses on the change in Facebook, now Meta's own presentation of its services over time. So a little bit in the Jason category of markets have changed, technology has changed. But it's a very interesting ruling that even if there were monopolistic behavior early on, the judge says it has to be ongoing at the time he's making the determination, citing the FTC Act, in order to enjoin illegal behavior and prevent it from continuing. Thoughts on this?
So first, let me just say, because I do some work for a governmental agency, everything I'm saying are my personal views. So neither anybody on the panel nor any governmental agency has to be responsible for them. But look, the case actually goes off, as you say, on a particular provision of the FTC Act. I'm not an expert in the FTC Act, and I'm not going to give a legal judgment on that. What I do think is that there are a few things out of this case that trigger important issues that are broader than the case itself. Let me note three. The FTC, and I should say the FTC is appealing this case, has filed a notice of appeal to the DC Circuit. So here are three. One of the FTC counts said that the acquisition of Instagram in 2012 and WhatsApp in 2014, along with other conduct, the denial of API access to certain other players in the marketplace, constituted a course of conduct that aided monopoly maintenance. I want to make one point that's very important here. Here, as in other cases, the allegation is that a monopoly acted illegally to maintain its monopoly. This is important. There need not be any difference in market share before or after, because maybe competition would have eroded market share. We're looking for actions that fundamentally raised or strengthened barriers to entry to make it harder for competition to work than it was before the maintenance conduct, okay? So the FTC alleges a course of conduct. It doesn't go forward in part because of the same provision of the FTC Act that Gene noted. But I want to make a point about this. In a monopoly maintenance case, monopolies may have multiple tools to slow down the competitive process. There may be lots of gears into which some sand can be put. It's very important that if each of these acts, each act of putting sand in a different gear is anti-competitive. That the effects be understood to be the totality of the effects from different anti-competitive actions. If one is done by contract and one is done through the unilateral refusal to continue a relationship, and they are both anti-competitive, and you could have lots of debates about when they would be, then the effects ought to be counted up. This is not always accepted, but it's fundamentally important in a monopoly maintenance case. We need to know the whole impact. Second, so here's what I want to talk about Instagram, because everybody agrees that Instagram was in the market. It is a competitor to Facebook in what the FTC described as the personal social networking market. Okay. Acquired in 2012. TikTok enters into 2018. The court says this may have been a market in which Meta had a monopoly as late as 2020 when the case is filed, but by 2025 it no longer does because Facebook, Instagram, TikTok, and YouTube are all providing very similar competitive services, which are illustrated by a wonderful slide that shows each of the apps displaying the same dog. And let me just tell you, as a matter of litigation advocacy, if you can show a picture of a dog, you're in great shape. So the judge says, look, there's no monopoly now. And again, as an interpretation of FTC law says, there's nothing for him to do. But this is, I think, the antitrust policy question. Let's assume the judge believes, I think he does, that there was a monopoly in effect for some period of time. That monopoly could have had continuing effects. Let's think about it. The market that the judge notes as having the major meaningful competitors today is Facebook and Instagram, both owned by the same company, plus YouTube, different company, plus TikTok, different company. 3 companies. A reasonably important question would be, if there had been no monopoly for some set of years, let's say 2012 to 2020 or just 2018 before TikTok enters, would we have more competition today? Would we have more than 3 companies? Would more innovation be coming to consumers? If so, that would be continuing effects. And to my mind, I don't know, it would be a curious outcome if antitrust law of monopoly maintenance couldn't reach those continuing effects. Third point, remedies. I think in a monopoly maintenance case, the key goal of remedies is to lower barriers to entry that have been artificially heightened. That's what restoration of competition, the competitive process is. So I think the core test of a remedy is, does it have the effect of restoring competition, of lowering entry barriers? In this case, the Meta case, the FTC sought divestiture. Not surprisingly, it was a merger case. The allegation was it was illegal. There was illegality from Meta's acquisition of Instagram, so it ought to be divested. The judge didn't get to it because of the legal ruling he made. But I think if one is posited with that possibility of divestiture, and I'm probably a bigger believer in divestiture than some other members of the panel, but if one is positing that question, I think there's a lot of debate usually around divestitures about whether they're practicable or not. Lots of things can be made to look complicated. What I think one would want to know is, would the divestiture meaningfully lower barriers to entry that were artificially heightened? And if they would they do so in a manner that requires less continuing oversight, less judicial and law enforcement monitoring, because now economic forces, the new ownership, would work in the favor of more competition. I'm not saying that how that question gets answered in a particular case, and I'm certainly not saying it would always get answered one way in every case. But I do think remedies looking at the ability of of new entries, let's just take it that way, is very important. It's not, however, always a question of divestitures. Imagine a circumstance where the judge had found liability. One could assert, I don't know if the FTC did, but there are switching costs that are important. If data portability, the ability of a Facebook user to move contacts, friends, names of friends to a competing service might lower switching costs, that could be a very efficacious remedy. So there's a lot of choices to be made, but the guideline is the restoration of competition.
Yeah, that was a remedy the FTC did not seek. One could go back and think about that. The judge didn't seem open to it. And he never even got to remedy. But had he found liability, he clearly thought the market had changed substantially. And so the likelihood of a divestiture was very low. I mean, Nancy, does this fit the category of further waste of resources if this is what you're going to get out of it? Or
I think so. Audiences, there's a Zoom audience. I think so. And I think, honestly, if you think the market's changed a bunch, what's the cost of the divestiture? Like, you're not as worried I'm going to utterly destroy whatever this alternative market that he defined was. I will say, I think that market definition is an example of economics either at its worst or the misuse of economics. So my understanding is that something that was quite influential was, again, an experiment. So we love, as economists, we love when people can do experiments. But it was an experiment. Again, my understanding is, I didn't pay close attention to the trial, is that there was an experiment that was done that basically said, we're going to take away Facebook from you for 2 weeks, and then we're going to see what you spend time on. And we discovered that if you don't have access to Facebook and you used to be a big Facebook user, you spend more time on TikTok or YouTube or whatever. And so those must be in the same market, which the FTC had argued was not the right way to think about it. I think about that decision, the question of whether that experiment is informative, like somebody coming to me and saying, we're going to take away your Hyundai Ioniq for 2 weeks, and we're going to see if you go buy a Tesla. And if you do, then Hyundai and the Ioniq and Tesla are in the same market. But if instead you take the T or Uber for those 2 weeks that you don't have your car, well, then we have to define the market to be all transportation possibilities in the Boston area. And I think that experiment, because it's a short experiment, you're not going to uproot, as John explained, it takes a lot to move your entire social network from Facebook and coordinate onto something else. You're not going to do that for 2 weeks. You're going to play on your phone when you're bored on something else, but that doesn't mean they're in the same market. And I found that appalling.
yeah. So John, you were in the leadership of a major company that in an earlier generation had been challenged by the government for monopolizing the telephone market, AT&T, and holding out competitors. With that experience in mind, when you look at these cases, what jumps out at you? You've been through this before with the government, but this is different, right?
So I was trying to figure out what question Gene was going to ask, how far back he would go into my past. The one thing I would say about—
I bet you didn't prepare the stuff on AT&T for this panel.
yeah, it's like I have to go deep into my memory and deal with some PTSD from dealing with the breakup of the Bell system.
That was a frame relay?
There was a little bit of frame relay and a few other things in there. So what jumps out at me is the rate and pace of technological change relative to the rate and pace of government's ability to address that change through some form of, whether it's an antitrust consideration or a regulation, and they're just incompatible, right? I mean, they're kind of incompatible in the sense of, and I'll give you a little bit of the AT&T history here. There was the 1996 Telecom Act, which Tom talked about yesterday. And that act kind of started the process of trying to create competition in telecom. And that seemed right to me, to try to create competition. But the process and the way it was created, you still had some natural monopolies in the local exchange, basically. AT&T was not going to be able to reconstruct a copper network. You had a whole set of technological changes. So for example, you were going from analog to digital. And you were going from low bandwidth to high bandwidth through things like your coaxial cable into your home or fiber into your home, some other sets of technological changes. That really just upset the whole structure of how you think about regulating those entities, because you've just fundamentally redefined the industry boundaries, right? So we did this little experiment, I think we were talking about the other day, this little experiment with the board of AT&T. And the head of Bell Labs, and I did this thing with the board where we played for them a voice call over two different networks. One was an internet network, digital, and the other one was an old analog. And we asked them, which one do you think is analog and which one do you think is internet and which one is better? And they got it wrong, completely wrong, right? They assumed analog was better. And the answer was, no, that's the internet voice that you liked that was better. And if we don't make that transition, we're in trouble. And the second piece of it was basically, how much bandwidth do you think that voice call takes when you're looking at a coaxial cable? And the answer was, it's trivial bandwidth. Okay, so all of a sudden you've taken what is a historical voice market, and it's now voice, video, data over the same infrastructure. And managing that transition through a regulatory process or an antitrust process, I mean, the AT&T breakup took decades to kind of work through. So kind of where it leaves me in this context, one, I kind of, like if I look at the Google search case, I agree with what Nancy said in the sense that, okay, if you look at what the court found, relevant product markets and general search, Google has monopoly power. Okay, that in itself is not a problem. It's what you do to either create or maintain that monopoly. Well, they conclude the distribution agreements are exclusive and have anti-competitive effects, and it's a valid pro-competitive justification. Okay, the government had to prove all four of those. It did. They were found liable and in violation of the antitrust laws. And then the answer that was proposed by John and others was unfetter these markets from Google's exclusionary conduct, remove barriers to competition, deny Google the fruits of its statutory violations, prevent Google from monopolizing. This is a case where the antitrust actions are so far behind where the markets are moving and where the firms are moving. This is a waste of time, in my view. Right? Because if I'm a business and I look at, if I'm Google and I look at this outcome and I'm not prohibited from paying money to get, you know, my relationship, I keep it as a one-year contract. That means it can't be exclusive. John educated me on the law on this a little bit. It doesn't change nothing has changed. Yes, I was found guilty of violating the antitrust laws and there's no consequence for me. I just go about my business. Right? And you can't then look at antitrust, in my view, as a solution. And it's particularly firm specific and it's ex post, right? So you've got to find, I mean, I would agree that I don't think antitrust is going to solve our problems. I did look up the judge in the case. You know, he did say much has changed since the end of the liability trial, though some things have not. And he talks about how Google has a dominant position. And he goes, but artificial technologies, particularly generative AI, may yet prove to be game changers, right? Now, who knows how that factored in to his decision, because it wasn't part of the evidentiary base of the case. So he can't really look at that in a legal sense, I think. John will correct me if I got that wrong, but I don't think he can really look at that. But it does affect then his notion of the conservatism, the Jason's small c kind of conservatism. Wait, there's a lot going on here, and this could really change everything. Now, the problem I have, and I saw this with the AT&T breakup, is that as you say, okay, hypothetically, let's say AI is really going to change the world. Okay, and maybe it is a real game changer. Okay, but then you have to ask, I mean, the judge went on to say, courts must approach the task of crafting remedies with a healthy dose of humility. Here, the court is asked to gaze into a crystal ball and look to the future, not exactly a judge's forte. Okay, so after saying that, he just punts on the whole thing, right? I mean, he just kind of says, "I don't know what to do." That's a layman's interpretation, not a legal interpretation. But I don't know what to do. But assume that AI is really going to change it, and if the judge is trying to create competition, he's got to say, even though he doesn't want to, what does the future potentially look like? And if you look at Google, it is by far the strongest, in my view, the strongest position to deal with AI. They are vertically integrated. If you take the AI technology stack, they have all the pieces, and they're probably the only firm in the world that really does have all the pieces, right? And so you're naturally, in my view, kind of setting them up to actually potentially expand the moats and control more of the AI sphere than you were anticipating.
Could I just jump on that to say, I think also, again, that focus on, well, AI may change anything. First of all, the same argument was made in 2013 with respect to mobile. And yeah, it changed things. It made Google even more dominant. So if you look to history, I think that wouldn't be so
So you're
comforting.
agreeing with me that it may put Google in a stronger position.
Yes. And moreover, what he heard testimony about and concluded in the liability phase was that the source of Google's monopoly power was its control over distribution. It's not about what gets served up. It's its control over distribution. And if you leave that unchanged, AI Gemini may serve up something different. In fact, it looks as though that's going to benefit Google even more because fewer people are clicking on search results. So Google gets all of the ad revenue if you show up on the Gemini search result page and just stay there. But it did nothing to affect the distribution.
So
Let's get Jason back.
I just want to have 30
By the way,
seconds.
Tom, it's his fault. He chose to sit as far away
I'm
from the
good at it.
moderator as possible, so I feel guilty. But so
I'm going to get him in a second.
just a few things here. One is, for me, the small c conservatism is actually most important when it came to AI, because if something got in the way of development of AI, I think it would be quite bad. And if something helped it, it would be quite good. I thought, a lot of these revolutions we've seen, sort of the shift to PC overthrew IBM. The shift to the cloud didn't overthrow Microsoft, but it created Google and other things. Mobile then didn't create new things, and I was worried that AI wouldn't create new things either. But first of all, it has. Second of all, there's sort of an old joke about antitrust that you look at a company, see it has high prices, and that's an antitrust violation. See it has low prices, that's predatory pricing, it's antitrust violation. Has medium prices, it must have done price maintenance, that's an antitrust violation. A year ago, people were saying the problem with Google is it's so big that it's like a lazy sort of Orovian type of monopolist, and it's not developing AI, and so it needs to be broken up, otherwise it'll never develop AI and be innovative. Now it sort of did code red, got quite good with Gemini 3, and it's sort of that it's too good at AI. To me, it looks like a quite healthy space. I think Google may win, but every month there's a different company ahead in the AI space. And by the way, scale matters quite a lot. So I don't think we're going to end up with, 5 foundational models, as long as there's a few and as long as there's an ability to enter. So to me, on the search part, on the markets when it comes to Meta, as Nancy said, on the ad tech, I strongly agree on all of that. The place that makes me most nervous is if you think you're getting in the way of AI, and if Google ends up doing really well in AI, I think we'll all benefit from that, and that's a good thing that I'm perfectly happy about.
So, lots of disconcerting here about the antitrust cases, how they went, how they're going, what they're capable of doing from Mike's perspective. What do we do?
Well, first thing we do is we find Mike's dog. Okay, because he talked about his ability to make decisions, and this is clearly got to be the kind of solution we're looking for.
Pass that on.
Good. Look, I'm not the antitrust guy sitting here with all this antitrust.
Well, you ran a major
But
communications
it strikes me,
agency.
but it strikes me that, the title of this session today is, Has Antitrust Tamed the Tech Giants? No. Okay. We have anything else to
Easy
discuss?
answer.
No. Okay. The discussion that we've been having today, or that I've been listening to today and learning from, is kind of like antitrust itself. It's backward looking. All right. And let's go back to the Google case for a second. Yeah, Judge Matta came out with a guilty finding that was damning and held to the antitrust statute. Then he turns around and says, but things have changed so much because of this technology. And so he is making a decision about a singular case using two separate tests. And what worries me is that, yes, we need to have antitrust enforcement, but we also need to have the ability to keep up with the changes that are happening, that are going on with technology. And that the structure of antitrust is not the way to do that. And Judge Matta is exhibit A, B, and C. And so then we have to ask the question, okay, how do we do that? We need to empower sectoral regulators. And we also need to have to recognize where things are going and to say, wait a minute, throughout history, when antitrust has proven not to be sufficient, a specialized regulatory agency with expertise was created that works with antitrust, that works with judiciary, but brings an agility that doesn't exist in antitrust per se. And so I think the discussion, where this discussion leads is, yeah, we do have a simple one-word answer to the question being addressed. But that the real question is, okay, and what the hell do we do about it?
All right. So Jason, you had been requested to do an analysis for the UK government, did a report. You probably had a variety of ideas about antitrust going into it. Now we've had these new experiences. Reflections on what you were proposing then and what you think now at this point next step should be.
Right. I mean, a few things. First of all, the UK is a medium-sized economy, and there's a limit to how far it ought to go, conditional on others not doing things, because you can always just degrade the policy, degrade the product, or divest and leave the UK entirely. So it shouldn't do the global optimum. It should do something else. And when I did that, my hope was that it would encourage something to happen in the United States. Certainly, Tom, Jonathan, Gene, I think all three of you were part of the effort to develop things for the United States, and it got nowhere because, Mike, you think 6 years is a long time between report and policy.
Yeah.
The sort of median time in the United States is infinity years, at least in my own personal experience. So 6 felt is like shorter than infinity, by infinity, in fact. So that's sort of the first thing. The second is, I think in some sense no judge is smart enough to figure out how to do all of this. Now, a regulator, I'm nervous too, but I feel better about. And I looked at open banking in the UK, and it turned out you couldn't just pass a law and say the banks had to open up their APIs. You needed to figure out the details of where the privacy mattered, where the privacy didn't. You needed to actually have a lot of expertise on the regulatory side to deal with the enormous amount of expertise on the other side, where people were making claims that were sometimes correct about why they couldn't do it and sometimes not correct, and it wasn't self-executing. So having judges do it, I don't love. The other thing, advantages of ex ante regulation is it's it may be slow, but it's less slow than regulation is. So I guess I still like the UK type of model. But I am a little bit less motivated by the question than I was 7 years ago for the reasons I said, that I think if you had asked me where we'd be now, it would be that two of the, big 4 or 5 tech companies would have AI and no one else would. And instead, some of the big tech companies have tried and really fallen flat on their faces in the same way that Google did when it created Google Plus or whatever it was, their social network, or Meta basically did with Threads. And then we have Anthropic and OpenAI plus tons of other things that might come up. So I do think the problem might be a little bit less bad than I thought, the dynamism a little bit more, but that's fully compatible with an ex ante regulatory approach. And, and insofar as we don't have it, I think antitrust is a perfectly good thing. And I'm going to think about what you said, Nancy, about if there's sort of a low probability of being caught and a small penalty conditional on being caught, is that a really toxic combination? So that's worries me and gives me pause on everything I just said.
Can I ask you a question, Jason?
Wow, this
Can I ask a question? So you were saying, one of the things like, Google could dominate in the AI space in some way, but you may have to live with that because you don't want to impede the progress of AI. But my concern is that if AI is dominated by Google, like how many of you have Gemini and use Chrome and go in and do a Google search? How many of you do regularly do a Google search? I go in and do a Google search. I'm linked into Gemini. It immediately gives me a Gemini readout as well as my search results, right? So they're starting to tie these things together, right? And that's going to be, I'm not sure that's advancing AI as much as it is building Google's moats around AI to protect a kind of dominant position.
Right. But 6 months ago, Google was way, way behind, and they've gotten a lot better. And if that's why we all end up on Google AI, because there was incredibly stiff competition, they did Code Red, and the combination of Sergey Brin and all the talent there made them better than everyone else. That's fine with me. If no one else could really compete and enter the space, then I become much more nervous. But boy, does it look like, a lot of people can compete and enter the space.
So let me give you an alternative narrative. My son works for Google for quite a while. And everybody was being incredibly negative. Google's way behind in AI. And his comment to me was, no, you don't understand. They have all this stuff in the background. They're just concerned about the antitrust cases against them, and they don't want to start rolling this out until they've gotten through much of that.
I had heard that right after ChatGPT came out, and I wasn't just from you.
So you and I had this conversation.
But a year later, they were not worried about the antitrust stuff anymore, and they were genuinely stuck until they shifted. And the other thing, yeah, I mean that would be the main thing I'd say about it. And look, there's a OpenAI browser you can use now. Doesn't work very well, so no one's switching over to it. And I guess the last thing I'd say is a lot of this technology came out of a paper published by Google Research that any of us can read. That's a pretty cool thing to have that big a research department, use your monopoly profits for that. And today I read in the news, and I don't know if it's true or not, that OpenAI is actually cutting back on its science and its research, in part because it doesn't have monopoly profits and can't sustain it, and is just trying to focus on commercializing its commercializing its products, whereas Google had a little bit extra space to have that innovation that turned out to be an enormous.
let me but for 1 sec. Go
Go
ahead.
ahead. No, you go.
No, I want to be yelled at by Nancy.
No. I would just say, I think you've come back to John, which is that is exactly the argument that AT&T made for decades. The monopoly telephone company, we do soup to nuts, we're vertically integrated, we are your fantastic US company.
The biggest defender of AT&T's monopoly position when the government was trying to break it up
Secretary of Defense.
Defense Department.
The Defense Department.
But I will say, I think that economists who have looked at that have said that that actually retarded innovation substantially in the telecom sector. I mean, think about how late we were to the mobile game in the US. And so I think you're being a little optimistic in thinking if you've got the big protected monopoly that doesn't have to worry about anybody coming after it, that it's going to keep innovating and producing wonderful things.
Google's savings in, Google's increase in cash flow in YouTube as a result of the fact that they had AI capabilities to sort through, identify pictures, better target, was greater than the money they spent on the development in the Skunk Works. They developed this for their own purposes, not for the purpose of advancing AI, qua AI. How do I continue a business that built algorithms to answer questions, and it was a logical next step, not a breakthrough next step.
I mean, I think the big difference between, and Google is a little bit like AT&T when it comes to search. I don't think it's like AT&T when it comes to AI. There were not the equivalent of these other AI companies, nor were there things. I mean, the other thing on AI we haven't talked about is
you're
DeepSeek,
talking about 5 years from now.
I mean, the other thing on the AI space is DeepSeek. It has to sort of change your view. It turns out that there's more ability to enter, more ability to compete, even if they exaggerated how little compute they used in all of that. You know, you could not have had the equivalent of DeepSeek for the American telephone network that all of a sudden came in 1979 and overthrew AT&T.
Sure, it was called MCI. No, but I mean, long distance, right, John? I mean,
no, they opened it up.
It was called MCI. They used digital technology to come in and challenge in what had been switch circuit, long distance, expensive capital plant, expensive to operate. And Bill McGowan says, I got another way of doing it.
So on the innovation side, I'm going to be a little bit on Jason's side on this. One of the things that Google has done, they are investing heavily in innovation in the AI space, right? And one of the things they did, they were stuck a little bit. And there's a guy named Noam Shazir, and he had been at Google for 20 years, and he left and started his own company. And he had just been starting up, and Google said, "We're stuck. We've got some bugs in our Gemini aspect. It's not functioning as well as we would like." So what did they do? They did an acqui-hire. They went out and bought his company for $2 billion.
For how many? Right, for billions, right.
$2 billion. And they really just wanted him. And actually, and I was saying, this is ridiculous that somebody makes that much money. And my son pointed out to me that there was a bug in a kind of software structure, and he fixed it within 3 months. And the $2 billion was a small piece of the benefit that came from having.
But it wasn't. But it wasn't Google's innovation.
It was hiring
that he brought. Okay, it was Google's deep pocket that they got from monopolistic practices. See the Meta decision.
Okay. Are we over time? I don't know how far. Okay, we are over time. So what I want to thank everybody for coming and participating. I want to just say that while we're waiting for the UK regulations to unfold and the European regulations to unfold and the non-existent US regulatory framework to hopefully someday become something, my guess is you're going to see the next government case will be US versus Google for monopolizing the AI market. So stay tuned. Thanks, everybody.